Have you ever changed your patent practice based on a case that came out after you became registered as a patent practitioner? I know that's happened with me. And we have a case right now that we're watching fairly closely, and it's American Axle Mfg versus Neapco Holdings. We are on part 3 of our series, and we are addressing the dissenting opinions. Hi, I am George R. Meyer. I am a patent attorney and have learned much along my patent journey of about 30 years. With these videos, I will share tidbits that you can hopefully implement within your practice. Subscribe to this channel to make sure you don't miss any of our videos. Okay, let's go to today's topic. This is part 3 that addresses the dissenting opinions in American Axle Mfg. These dissenting opinions come from 2 sources. One was that the original 3-judge panel reheard the case and issued a new opinion. And there is a dissenting opinion from that rehearing panel, but there's also a number of dissents that were within the denial for a motion for en banc rehearing. That was denied, heavily split 6-6. But there were a number of opinions that were filed. So in this, we will be addressing the dissenting opinions both from the 3-judge rehearing decision as well as the en banc motion. We're going to briefly hit the technology because we've addressed this in more detail in part 1. This basically has to do with tuning the propeller shaft so that it doesn't vibrate so much. And the propeller shaft is the item 20 in the center of figure 1. There are 3 types of vibrations that are relevant that they disclose within the patent application. There's bending, shell, and torsion. According to the patent, people would adjust the propeller shaft to reduce bending, shell, or torsion vibrations, but only one, not more than one. Figure 4 includes a very simple view of what the propeller shaft looks like, and this has 2 liners within it. Figure 8 illustrates one of the liners, which is basically a hollow tube made of multiply cardboard with an elastic lip that goes helically around the outside of the liner. Figure 9 includes a cross-section right at where that elastic resilient member lies. Most of the liner is made up of the core 310, intermediate members 312, and the cover member 314. So when they're adjusting the mass and stiffness of the liners 204, it's mostly going to be the items 310, 312, and 314, and those will be used to address vibration mechanisms. Claim 22 was invalidated by the 3-judge panel, and Claim 22 is a method comprising providing a hollow shaft member, tuning a mass and a stiffness of at least one liner, and inserting the at least one liner into the shaft member, wherein the at least one liner is tuned to absorb shell mode vibrations and tuned for destructive interference of bending mode vibrations. Now the text within the brackets is my text. I think in the claim they talk about resistive attenuation, which is absorbing vibration, and reactive interference, which we would think of as destructive interference. So Claim 22 addresses both shell and bending mode vibrations. And just from what I can gather, it sounds like people know how to do the tuning for any of the individual types of vibrations. Now this is likely going to be compared to Claim 1 in the Deere patent, and this comes from Diamond v. Deere, which is a Supreme Court case that held that this Claim 1 did include patentable subject matter. So the length of this claim, notice this is much longer than our Claim 22. And Claim 22 that we had was much longer than Morse's telegraph patent Claim 8, which was held invalid. Some of the opinion seems to suggest that the length of the claim may come into play. But we basically have 4 active steps. But before we start, let me point out one thing that's about, 3/4 of the way down. We have an equation, and it's that the natural log of v equals cz plus x. V is going to be our calculated time. C is a constant related to the activation energy, and X is also a constant. That's related to the geometry of the mold. The only variable is Z, and Z is the temperature. So what's going to happen? You can see about 40% of the way down, we start an interval timer. We then determine a calculated time based on a temperature reading. You compare the elapsed time to the calculated time, and if the elapsed time is at least the calculated time, stop. Otherwise, continue with another time interval. Now, the claim doesn't literally say what I have in these 4 steps, but I put it in this format so it becomes easier to understand. And keep in mind, determining the calculated time uses the Arrhenius equation. Now, prior to this point in the opinion, they were talking a lot about the recent Section 101 cases, both at the Supreme Court and at the Federal Circuit. And they went on to say, while many of these cases having result-focused functional character of claim language involved the abstract idea category, the same principle necessarily applies in natural law cases. Now, the one thing that stood out for me is, okay, functional claim language. But elsewhere, they had also that what is missing is any physical structure or steps for achieving the claimed result. I don't know about you, but for me, this sounds like the court wants corresponding structures or acts. So the question becomes, is 35 U.S.C. 112F being merged into the 101 analysis? So is tuning step plus function? Now we need to keep in mind where this is as far as procedure. At the district court, the case was dismissed on a Rule 12b6 motion, but was solely based on 101. The problem is the court did not hear anything on 102, 103, and 112. They were not fully briefed because the grounds is only 101. Let's address some of the dissenting opinions. And the first one we'll hit is Judge Moore's dissent. And this was actually, she was part of the 3-judge panel. And she had a dissent in that decision on rehearing. And she says the majority makes 3 critical errors. First, the majority creates a nothing more test. That is, Claim 22 is nothing more than application of Hooke's law. Well, there's a procedural issue. This was not fully briefed and argued at the district court, that Claim 22 is nothing more than Hooke's law. The majority does not consider unconventional claim elements. And lastly, and this is the biggest problem that everybody's spotting, the majority uses a blended 101-112 analysis. Now, Judge Moore refers to this as enablement on steroids, and that implies 112A, not 112F, because 112A has enablement as a requirement. 112F is means plus function, step plus function. But overall, Moore does a good job of addressing the nothing more than Hooke's law because she points out frictional dampening is also involved. The dissents assert the majority requires a more detailed action-by-action description in the spec, pulling enablement into a 101 analysis. I don't think that's the case. I think this is really more of a step plus function issue rather than enablement under 112A, because notice the court was asking for physical steps and acts to provide support for the function. Well, that's corresponding structures and acts that you have from 112F. In Newman's dissent, she asserts that the claim breadth is not a 101 issue because there was a lot of discussion by the majority on how broad this functional language is. But the thing is breadth has to do more with 102, 103, and 112 written description issues, not 101. And she said that this alone warrants en banc review because it needs to be corrected. Another dissent was OMalley's, and hers was based a fair amount on procedural grounds. The problems I perceive with the majority opinion are threefold. It announces a new test for patentable subject matter at the 11th hour and without adequate briefing. Rather than remand to the district court to decide the issue in the first instance, it applies the new test itself, and on its own motion construes previously undisputed terms in a goal-oriented effort to distinguish claims and render them patent ineligible, or effectively so. So OMalley's was basically, you are deciding on appeal issues of fact and other things that should have to have been resolved first at the district court, and they weren't done. So it should be sent back down. And Judge Stoll, I agree a lot with what she has to say in there. And a lot of it is repetitive of some of the stuff that Judge Moore had. But looking at more from a technical perspective where technology meets the law, this I think is excellent. It's the way I think too. Assuming that Claim 22 applies Hooke's law or any other unnamed law of nature, the claim seems sufficiently specific to qualify as an eligible application of that natural law. The claim identifies other variables to tune, including a mass and stiffness of at least one liner. It requires that the tuned liner attenuate specific types of vibration, including shell mode vibrations and bending mode vibrations, and further requires that the tuned liner is inserted in a hollow shaft member. With this level of specificity, Claim 22 appears to be properly directed to the application of the law of nature to a new and useful end, not to the law of nature itself. I totally agree with Judge Stoll on this. So Stoll is concerned about the majority's new nothing more test. The claims involve nothing more than Hooke's law. Stoll's quote and other surrounding text is in line with the thinking of many of us patent practitioners. I know I agree with her quote. Stoll raises the preemption issue. And what preemption is if you are trying to exclude all uses of a natural law or a natural phenomena, you cannot get the claim because you cannot preempt all practical uses. But the question is, what's being preempted? Hooke's law? You gotta be crazy. People have been using Hooke's law forever. All you have to think about is a spring scale. This would be like your weight scale in your bathroom. Many of them are based on springs. So is the use of Hooke's law for damping vibration of rotating cylinders being preempted? I don't think so, because it appears as though this is likely in the prior art. Keep in mind that the background section of the patent does address the bending mode vibrations. I think the bending mode vibrations are the ones that are more closely related to Hooke's law. Okay, in our next episode, we will conclude our series, and I will address a case if I was a judge or justice. And I think this is a fairly simple case, but it really goes in a different direction from what a lot of these dissents are saying. Now, regardless of the outcome, many practitioners will change their practice. The question is going to be, how much will it change? Well, that's going to depend on whether or not the Supreme Court grants certiorari, and if they do so, what the Supreme Court says. We will address practice tips depending on the outcome in that, and we hope to see you then. If you like this video, give us a like and leave a comment. Remember to subscribe to this YouTube channel, or better yet, sign up for our email list at georgermeyer.com and get a freebie. Follow us on LinkedIn. Thank you for your time, and check our YouTube channel for the next part in this series. We hope to see you then. Bye.